social media, and Premium Times even made a big story yesterday that a sacked senator attends plenary without giving any perspective. The other side, there was no other side to the story. So I believe that it's important that I come and put on record what is the real issue. First of all, we're all aware of the judgment of the Federal High Court by Justice Kola Ole that determined that somebody, Air Marshal, is the candidate of the party. This is not the duty of the court to determine who a party's candidate is. It is the party that determines its candidate. However, because I have appealed, I don't want to go into the details of that judgment because it will be prejudicial. I'm already in the Court of Appeal. But to put the record straight, first, it is common knowledge, it is the law, that where the judgment of the Federal High Court is delivered and an application for stay and notice of appeal has been entered in the Court of Appeal, all the parties must take action. And that has always been the tradition. So there is no point that the Air Marshal will begin to blackmail and run around to say that he has a judgment that he needs to be sworn in. No, I have already appealed. I have served the Senate President, I have served the clerk, I have served everybody concerned, including INEC. The notice of appeal is here. I can show the press. We have filed our notice of appeal and motion for stay. This is the notice of appeal. This is the motion for stay, well entered in the Court of Appeal. And there are several Supreme Court decisions that said, you're journalists, you know, if an appeal and a motion is already entered, no party should take any step. So going around to say that I have a certificate of return, I have this, I need to be sworn in, this is trying to twist the Senate. And of course, if any institution will violate the law, the proceedings in the Court of Appeal, it should not be the Senate. If any other institution should violate the rules or the law, it doesn't have to be the Senate. So nobody should be put under pressure to say the Senate must sue somebody who only a trial court has just given a judgment and appeal has been entered. I need to put this in perspective. The second issue why he cannot even be sworn in is that the judgment of the court is unenforceable. That judgment cannot be enforced as it is. The judgment of the court, the order the court made here, I will read it to you, is that the court ordered that the clerk of the National Assembly shall immediately administer oath of office on the plaintiff as senator representing Kogi East Senatorial District. It is not the function of the clerk of the National Assembly to administer an oath of office. It is the function of the Senate President by our rules, Order 7 in the Senate Standing Rules, which is derived from Section 60 of the Constitution, is that every senator-elect shall, before taking his seat, submit his certificate of return to the Senate President, as well as asset declarations, and subscribe to oath and affirmation of allegiance, oath of membership as prescribed by the 7th schedule. There is no ambiguity in this. It is only the Senate President that can administer oath of office, not the clerk as ordered by the court. Therefore, if they want this order, this judgment to be enforced, what the only remedy they have is to go back to the court to go and amend or alter this order to do the right thing. But if you have this kind of order, which is unenforceable, and you want to untwist the Senate President, who is not even a party, who is not mentioned in this judgment, and the clerk of the House you ordered is not even a party in this suit. The suit is between Air Marshal, PDP, and myself. And you are giving an order to a clerk of the Senate who is not even a party to this suit. This is, any lawyers have said it, and it has been written that it is an unenforceable judgment. So I don't think that the man should go around blackmailing people that he must be sworn in. These two very serious issues are issues that will not allow him to be sworn in until the appeal is determined. And there are precedents. You are all in the National Assembly, both in the House and in the Senate, where trial court gives the decisions. Those people are still sitting. Am I the first person that is sitting in this National Assembly today as a result of judgment of the Federal High Court? The answer is no. So you can't be rules cannot be changed because of one person, because he thinks he's powerful or something. No. So today I said that I have to bring this issue to the fore so that Nigerians should know, so that this sponsoring stories on social media to blackmail or to untwist the Senate president or the Senate should stop. Any media man that is taking it should know the truth of the matter. The documents are here. I have filed appeal. I have filed stay. There's even another motion in court stopping all these things because of these steps that have been taken by INEC or so on to issue. There's another originating summons. So all these things, these people are parties to the suit. So you cannot take an action when there are pending suits in this thing. Lawyers know that. Everybody knows that. So I thank you today for listening to me, and I just needed to put this on record, that nobody in the Senate is doing the wrong thing. This is the law, this is the precedence, and this is what it's supposed to do. We should not be allowed, the press should not be allowed to untwist anybody to come and ask the Senate president to do what the Constitution does not allow him to do. If the court does not order him, he cannot. And if the Constitution says the clerk of the National Assembly, he cannot leave his office upstairs and come down to do it. It is here. If you want, I can give you copies of the judgment to look at. So thank you very much. I will wait for any question that you want to ask.
Very few questions because we have